our channel. Friends, today we will see MCQs of Civil Procedure Code. So friends, watch our complete video, like it, share it, comment on it. Don't forget to subscribe our channel. So friends, we will see MCQs on CPC with answer. Question number 1. Decree holder is. Answer is option number C, either A or B. Means option A, any person in whose favor a decree has been passed, and number B, an order capable of execution has been made. So means decree holder. Question number 2. Which of the following deals with the institution of suits in the Code of Civil Procedure? Answer is option number D. Section 26 deals with the institution of suits. Question number 3. Which of the following deals with the liability of ancestral property in the Code of Civil Procedure? Answer is option number C. Section 53 deals with liability of ancestral property. Question number 4. Under section 15 of CPC, every suit shall be instituted in. Answer is option number B. The court of lowest grade. Section 15 according to CPC, the court of lowest grade. Question number 5. Under section 89, the court shall formulate the terms of settlement and give them to the parties for their observation, and after receiving the observation of the parties, the court may reformulate the terms of possible settlement and the same form. Answer is option number D. All of these means number 1 arbitration, number 2 conciliation, and number 3 judicial settlement, including settlement through lok adalat, and 4th mediation. So all of these. Question number 6. The object of discovery is. Main purpose, object of discovery. Answer is option number D. All of these means number A, to elicit admissions. Number B, to obviate the necessity to produce lengthy evidence. And number C, to expedite disposal. So all of these. Answer is all of these. Question number 7. The words "it appears to the central government," which is the consenting authority in section 86 of Code of Civil Procedure, makes it clear that. Answer is option number B. The decision granting the consent is final. Question number 8. A agrees to sell his property to B for rupees 2000 to be paid to A on the execution of the conveyance. The purchase money payable to A is not a debt owing to him by B until the conveyance is executed. Answer is option number B. It cannot be attached before the execution of the conveyance in execution of a decree against A. Question number 9. The defendant, the editor and proprietor of a newspaper publish articles which refer to the Calcutta police. Without naming individuals, the plaintiffs, 6 of the members of the Calcutta police force, jointly sued the editor for damages, alleging that the articles were directed against them and that they constituted a libel. Here a libel was in the same words and in the same documents but of different persons. Answer is option number C. Both option A and B. Option A, the plaintiffs could not all be joined in one suit. Number B, there cannot in such cases be said to be done or the same cause of action. So option A and option B both. Question number 10. Which of the following deals with style of foreign rulers as parties to suits in the Code of Civil Procedure? Answer is option number C, section 87. Question number 11. Plea of res judicata. Plea of res judicata means option A. Answer is option A has to be specifically raised. Question number 12. Constructive res judicata is contained in. Answer is option number B. Explanation 4 to section 11. Question number 13. Principle of res judicata applies. Answer is option number D. To suits as well as execution proceedings. Question number 14. A decision on issue of law. Answer is option number C. May or may not operate as res judicata. Question number 15. A decision on an issue of law operates as res judicata. Answer is option number B. If the cause of action in the subsequent suit is the same as in the former suit, even though the decision on the point of law is erroneous. Question number 16. A decision in a suit may operate as res judicata against person not expressly named as parties to the suit by virtue of explanation. Answer is option number C. 6 to section 11 of CPC. Question number 17. Res judicata does not operate. Answer is option number C. Against a per forma defendant. Question number 18. In which of the following cases res judicata is not applicable? Answer is option number C. Option A and B. Means option A, consent or compromise decrees. Option B, dismissal in default. Question number 19. Principle of res judicata is. Answer is option number A, mandatory. Question number 20. With respect to the principle of res judicata, which of the following is not correct? Answer is option number C. Writ petition dismiss in operates as res judicata. Question number 21. In a suit where the doctrine of res judicata applies, the suit is liable to be. Answer is option number B. Dismiss. Question number 22. A decision or finding given by a court or a tribunal without jurisdiction. Answer is option number B. Cannot operate as res judicata. Question number 23. On production of a certified copy of a foreign judgment, the presumption as to the competency of the court under section 14 of CPC is A. Answer is option number C. Rebutable presumption of law. Question number 24. Validity of a foreign judgment can be challenged under section 13 of CPC. Answer is option number A. In a civil court only. Question number 25. Under section 13 of CPC, a foreign judgment can be challenged on the grounds of. Answer is option number D. All of the above. Means option A, competency of the court pronouncing the judgment. Option B, being obtained by fraud. Option C, sustaining a claim founded on a breach of law in force in India. All of the above. Question number 26. How many grounds of attack the foreign judgment have been provided under section 13 of CPC? Answer is 6 ground. Question number 27. On the ground of jurisdiction under section 13 of CPC. Answer is option number C. Both judgment in personam and judgment in rem can be challenged. Question number 28. A person who institutes a suit in foreign court and claims a decree in personam after the judgment is pronounced against him. Answer is option number B. Can never challenge the judgment on the ground of competency. Question number 29. Which of the following instances can be held to be final order? Answer is option number D. Means all of these. Number 1. An order of a high court dismissing an appeal for the appellant's failure to furnish order. Number 2. An order that an appeal had abated. Number 3. An order in a revision reversing the dismissal of a suit and restoring it to the file of the lower court when such an order had the effect of reinstating a primary decree. Number 4. An order refusing an application under section 45 of the Specific Relief Act. Number 5. An order passed by a high court in insolvency proceedings. So all of these. Question number 30. Section 15 of CPC lays down. Answer is option number A rule of procedure. Question number 31. Under section 16 of CPC, A suit relating to immovable property can be filed in a court within whose local jurisdiction? Answer is option number A. The property is situated. Question number 32. Suit in respect of immovable property where the entire relief sought can be obtained through the personal obedience of the dependent can be instituted in a court within whose local jurisdiction? Answer is option number D. All of the above. Means number A, the property is situated. Number B, the defendant voluntarily resides or carries on business. Number C, the defendant voluntarily resides or personally works for gain. All the above. Question number 33. Place of institution of a suit in respect of immovable property situated within the jurisdiction of different courts has been provided. Answer is option number A under section 17 of CPC. Question number 34. Section 18 of CPC provides for. Answer is option number C. Place of institution of suit in respect of immovable property where the local limits of jurisdiction of courts are uncertain. Question number 35. Place of suing in respect of suits for compensation for wrongs to persons or immovable property has been dealt with. Answer is option number B under section 19 of CPC. Question number 36. A suit for compensation for wrong done to the person or to movable property where the wrong was done within the local jurisdiction of one court and the defendant resides within the local limits of another court. Answer is option number C, either A or B at the option of the plaintiff. Means option A, can be instituted in the court within whose local jurisdiction the wrong has been committed. Number B, can be instituted in a court within whose local jurisdiction the defendant resides. Either A or B, option of the plaintiff. Question number 37. X residing in Delhi publishes statement defamatory to Y in Calcutta. Y can sue X at. Answer is option number D, either in Delhi or in Calcutta. Question number 38. Suit under section 20 of CPC can be instituted where the cause of action arises. Answer is option number C, either wholly or in part. Question number 39. In case where there are more than one defendant, a suit can be instituted in a court within whose local jurisdiction. Answer is option number C. Both option A and B are correct. Means option A, each of the defendant at the time of commencement of the suit actually and voluntarily resides or carries on business or personally works for gain. Number B, any of the defendant at the time of commencement of the suit actually and voluntarily resides or carries on business or personally works for gain and the defendant not so residing etc. acquiesce. So option is A and B are correct. Question number 40. A suit for damages for breach of contract can be filed at a place. Answer is option number D. Option A and B both. Option A, where the contract was made. Option B, where the contract was to be performed or breach occurred. Question number 41. A suit relating to partnership may be instituted at a place. Answer is option number D, all the above. Means option A, where the partnership was constituted. Number B, where the partnership business was carried on. Number C, where partnership accounts are maintained. All the above. Question number 42. A suit relating to partnership dissolved in a foreign country can be filed at a place. Answer is option number B, where the parties to the suit resides in India. Question number 43. Objection as to the place of suiting. Answer is option number A, can only be taken before the court of first instance at the earliest possible opportunity. Question number 44. Section 21 of CPC cures. Answer is option number D, both. Option B and C. Option B, want of pecuniary jurisdiction. Option C, want of territorial jurisdiction. Question number 45. A suit to set aside a decree on the ground of lack of territorial jurisdiction is barred. Answer is option number B, under section 21A of CPC. Question number 46. Parties by their consent or agreement. Answer is option number C. Can oust the jurisdiction of one of the courts when there are two courts simultaneously having jurisdiction in law. Question number 47. Section 20 of CPC does not apply to. Answer is option number A. Arbitration proceeding. Question number 48. Agreement between the parties to institute the suit relating to dispute in a particular court. Answer is option number C. Both option A and B. Means option A does not oust the jurisdiction of other courts. Option B may operate as estoppel between the parties. Question number 49. In cases of the commercial contract between parties of two different countries, the jurisdiction of the court shall be governed by. Answer is option number D. Rule of freedom of choice, that is intention of the parties. Question number 50. A corporation under section 20 of CPC is deemed to carry on business at. Answer is option number A. Its principal office in India. Question number 51. In case of cause of action arising at a place where a corporation has a subordinate office, the corporation is deemed to carry on business. Answer is option number C. Option A and B both are correct. Option A, its principal office in India. Option B, its subordinate office where the cause of action did arise. Both option A and B. Question number 52. In every plaint under section 26 of CPC, facts should be proved by. Answer is option number B, affidavit. Question number 53. According to section 27 of CPC, summons to the defendant to be served on such date not beyond. Answer is option number A, 30 days from the date of institution of suits. Question number 54. The court may impose a fine for default upon a person required to give evidence or to produce documents directed under section 30 clause B of CPC, and such fine as per section 32 clause C not to exceed. Answer is option number C, rupees 5,000. Question number 55. Under section 39 subsection 4 of CPC, the court passing the decrees. Answer is option number D, neither A or B. Question number 56. A private transfer or delivery of the property attached under section 64 subsection 2 shall not be void if. Answer is option number A, made in pursuance of any contract for such transfer or delivery entered into and registered before the attachment. Question number 57. The court under section 89 subsection 1 of CPC can refer the dispute for. Answer is option number D, arbitration or conciliation or lok adalat or mediation. Question number 58. The court can award compensation against plaintiff under section 95 of CPC not exceeding. Answer is option number C, rupees 50,000, and this amount not be exceed the limit of its pecuniary jurisdiction. Question number 59. Under section 100A of CPC, where any appeal from an original or appellate decree or order is heard and decided by a single judge of a high court. Answer is option number A, no further appeal shall lie from the judgment and decree of such single judge. Question number 60. Second appeal. Second appeal shall not lie from any decree as provided under section 102 of CPC when the subject matter of the original suit is for recovery of money not exceeding. Answer is option number B, rupees 25,000, not exceeding 25,000. So friends, these are MCQs of CPC. Thank you.